Islam, everyone. Welcome to the House of Reawakening the Mind. I am Abdullah Mosi Bey, and this is Shem Malachi Bey. We are of the Moorish and Pure Restoration Caucus. And tonight, the topic, we have an interesting topic for you. Separate, not equal. Separate, not equal. And we're going to analyze. Before we get into it, we're going to analyze a news report regarding the rise of the Moors, and we're going to analyze it from a jurisprudence perspective. It's very important that we look at things in its proper perspective. There's been a lot of misconceptions about what this Moorish movement is about. So we're going to play the news report. I thank you all for tuning in, and trust that you will be illuminated tonight upon hearing us deliberate and analyze the points. All right, so we're going to play the recording.
It's about 4 a.m. It's so we've been out here since 1:53 a.m. It is July 3rd, 2021. We are in North America, Morocco. We are on the Interstate 95 near exit 57.4.
It's just bizarre. Now, this weekend, 11 heavily armed men wearing tactical gear and claiming exemption from U.S. law and state law shut down part of a Massachusetts interstate during a traffic stop. Well, they say they're part of a group that calls themselves the Rise of the Moors and say they were on their way to, quote, training. Well, the entire ordeal, it ended after an 8-hour-long standoff with police. And for reference, the Capitol breach lasted about 3 hours. Now, some of the members were arraigned yesterday in what became a pretty chaotic hearing.
How can I get a probation? How can I answer these questions of probation if I've not been charged? I've not committed a crime. I'm not guilty.
I'm not a sovereign. I'm a national. All right. You understand? I am not a 13th or 14th Amendment fictitious entity. I am a free Moor. I am a nationalist, a living, breathing man. I am not a fictitious entity.
I'm not black. I'm not Asian. I'm not Hispanic. I'm not Latino American. I am well within my constitutionally secured rights to carry and bear arms as a Moorish national. There is no probable cause because we don't carry weapons. We carry arms.
It's a reasonable question to ask. Why isn't this being covered by the media? And what else do we need to know about them? Well, joining me now are two men who know these types well.
Okay, what we have here is a group of Moors through consanguinity demonstrating military power without a declaration or proclamation from a government, head of state. Now, do they have the rights to bear arms as Moors to protect their culture, their land and states? Absolutely. But there's no political identity. There's no national political identity to what they are doing. And so what they are doing is they out there on the freeway, highway, with arms and claiming to be Moors, consanguinity, but have a political allegiance to the United States of North America and claiming an allegiance to the state of Rhode Island. Now, that's a political identity, but here's the thing about it. When someone under the title of Negro, Black, Afro-American, and colored, that is considered as a political identity of disnationalizing you with no rights. So the moment that you claim your protection through the Constitution, you have a right to say, hey, I'm a Moorish consanguinity. That's impossible to do away with descent, kinsmanship, or heirship through a heritage claim. But to make the claim to inheritance, there have to be a political, national political identity. I mean, there have to be a government in force or an ecclesiastical society that was existing that secure your rights to walk up and down that freeway on Moorish territory land. And what happened here was a tragedy. I'm glad he didn't get shot. I'm glad he didn't get shot. But what I'm saying is that you can't claim to have a political allegiance, national allegiance to the United States, and they pull a Moorish flag out. So what happened is they really don't know what to do with them. They kind of up for grabs. They can't even bring a jurist or expert in to even talk about that. They're bringing someone else in that has absolutely no knowledge, not a jurist, absolutely have no knowledge on international law or treaty making power between two sovereign powers. This is when you see them do this, that means they don't want to bring the jurist, someone that had real full knowledge, someone that will come and say, well, based on their claims as being Moors, they do have protection right under the treaty, but they have an express and implied obligation performance to be a resident or citizen of the United States. By quoting the Constitution, by quoting Rhode Island as a territory, then you don't know what's going on. So they don't have a national political identity. That's number one. They have a right to protect themselves. They don't get it messed up. Let's think about this. There's nothing wrong with claiming a Moorish consanguinity. What the problem is when you claim that, you don't claim an old country or state in the Moroccan Empire as a national political identity. You don't go under the umbrella or the flag. That comes through not being educated and not being taught on the proper concepts for jurisprudence and positive law. We haven't been taught that. So what happens is, I have something here that I'm going to read here on my computer. It's going to show you when you're dealing with international affairs, there have to be an embassy. It's number one. Because they went into the political jurisdiction of Massachusetts on Moorish land. What kicks in now is alienation. So when you bear arms like that, there have to be a government-to-government relationship, meaning that the government, executive branch, have to have knowledge that political country is operating, has a right to operate there, and that its nationals are secure. What I mean is that when the car they drive, they don't have no tags. They're in a state-owned car. The state's a registered owner and a bearer of the title to the car. There's no tags on it. Now, that's a violation of the treaty. That is a violation of the treaty because they're driving a vehicle with no tags. The treaty said that there should be a sign. There should be passports and there should be documents. That's coming from a government. A flag represents a government. So the problem is, let's deal with the situation. We got to see, don't get everybody, who will help them out? They had a right to this. No, listen to me. Let's deal with facts. Please. Let's not get emotional. Let's deal with facts. Let's deal with jurisprudence. Let's deal with positive law culture. Let's deal with equity, the value of the decisions and decrees and adjudication and constitutions and treaties that was passed. Come on, please. Let's stick with the principle, concept, the righteous principle and concept. They are driving cars with no tags on it. That's a violation of a Moorish treaty. Because the tag is not under the protection, the car is not under the protection of the country now, the political government. It's not under protection because, first of all, it doesn't have a sign, a tag. It doesn't detect it by flag, under flag. There's no papers or passport. See, this is real jurisprudence, positive law. They don't want this culture. Why wasn't a treaty where they said these documents are needed? Why? It's to separate a citizen from a national of two countries. So if one gets stopped, they look at the vehicle, it got a national political government sign there that's attached to Morocco. the head of state and the Ministry of Foreign Affairs, the ambassador, sends out, which I have here, I'm going to read. He sends out memos. He has scheduled meetings with the treaty nations. So there will be no conflict. I'm going to read something so y'all can hear it. I'm not just going to talk. I'm going to read something. The ambassador, the British embassy, watches and maintain and develop relationships between the UK and the United States. Now, the UK was here in Morocco before the United States was even formed. There was a political jurisdiction. UK, I want y'all to hear this because they messed the map up. The UK still have rights here. Yes, they do. They have occupying sovereignty rights. United States is carrying on as a trustee for them. But when their rights are violated, the treaty comes in. We dealt with a wide range of political, commercial, securities, and economical questions of interest to the UK and the United States. Our consuls team with Washington provides consular assistance to British nationals in the District of Columbia, Delaware, Maryland, Virginia, and West Virginia. Now, here in Delaware, we have the United Republic of Morocco. We have an embassy here. See, we know what's going on. So what we're doing is we scheduling, setting up to show you that as a government body, you have to be on the balance of international law. If you're not on a body of international law, meaning that if you're not claiming a population of people, you're not having elections, you don't have a written constitution, you don't have a military, you don't have political structure set up, you don't have civics set up, you don't have an industrial system set up, economics, you don't have a diplomatic relationship, meaning that you have a minister of foreign affairs that was appointed by the head of state and approved by the legislative branch. You don't have an embassy in the political occupying jurisdiction of that treaty nation. You're not set up right. And we're always going to be ambushed because we have to make sure that we apply these principles equally. Remember, they're going to apply this principle. They're going to educate their citizens. What we have to do is form our government, our societies, our map. We have to zone out the longitude and latitude. We have to claim our people, not just the ones that claim that they are awakened, the ones that's left behind, that's been crippled, that's been injured to the apartheid and genocide system. We have to claim them. When we do that and have a constitutional, executive, legislative, judiciary, administrative, when we do that, we're doing it. That's with the international community of civilized nations going way back. No way in the world that the Moors is going to be signing treaties and not be a most favorable nation. Had a currency system, a gold system, a silver system, bartering, economics, military, the Amir, the military, patrol the land. They try to paint you out that Moors was going around taking people for hostages and taking for servitude. No, they wasn't. The Moors was going around enforcing the boundary, protecting the boundaries of the land. Everything starts from the water. If you're not living on the land, you got two foreign nations on the land, they're dealing with land boundaries. But when they come across the sea, the sea becomes a political boundary that you can't let ships come there and do commerce because that could declare war, that could destroy your economy, and it can destroy your sovereignty. So what the Moors was good at is navigating the waters, protecting their political jurisdiction, not only on land, but on water. So what the Moors was doing there is they say they was doing what you call a military drill. Well, here we go. Government relation. Where's the memo at from the government? So what we have to do is we got to make sure that we get everything set up and we have our embassy in the political jurisdiction of the treaty nation. What I mean, if you got it in Delaware, you got it in West Virginia, you got it in the United States of North America, because they're all in a compact agreement. They're all in the allegiance. So we Moors have to come together and trust each other and learn. I mean, we have to go ahead and read and take for value and validate by reading and verify by reading the knowledge that we take in. It got to be verified. It got to be validated. And what we're doing is that we're letting people just jump off with conversations and statements and words, and we're not going behind them to validate that. We're not putting it on the scales of my eye. We're not weighing it to see where it comes out the weight, what the statement weighs in that. Now, where's these scales, Shem? Philosophy, the ancient philosophy of civilized nations that already been doing government, ecclesiastical and social. Well, Professor, you want to add anything?
Yes, we had the Moorish and Pure Restoration Caucus hosted a meet and greet here at the headquarters, and the Moorish and Pure Restoration Caucus hosted in November, on November 7th, a grand opening. And we go to the UnitedRepublicOfMorocco.com website. And on Wednesday nights, the Moorish and Pure Restoration Caucus for the past 4 months have been hosting Moorish body politic formation classes. There are 2 proposals that the Moorish and Pure Restoration Caucus has put, 2 motions that the Moorish and Pure Restoration Caucus has put on the floor that will be addressed. And that is the name of the Moorish central governing body, the United Republic of Morocco. That's put it as a motion. Another is the central location of the central governing body, and that is this Moorish territory where the political jurisdiction of the Great Britain political jurisdiction called Delaware operates. And then there is the seal. Another motion on the floor is the seal. So there has yet to become, there's not a embassy. There has not yet to be formed a more central governing body. As I said, for the past 4 months, the Moorish and Pure Restoration Caucus has hosting Moorish body politic formation classes. And this will be by the consent of the various Moorish body politics, as they will send their delegates to sign a Moorish treaty of liberty that will unite us politically as a central governing body. All right, there is no Moorish embassy. All right, there's no Moorish embassy. All right, so we just want to, just to provide some clarity for where we are politically at this time. We are in the educational stage, and also for helping other Moorish body policy and study groups facilitate through education of constitutional principles, government principles, and political legitimacy, how to build a permanent population of people, voters. All right, so this is where we are right now. There are 7 stages that we have on the UnitedRepublicOfMorocco.com website on establishing Moorish body politic. All right, so I just wanted to put that out on the floor. All right, so there's no Moorish embassy. All right, so thank you, Shem.
Thank you for clearing that up, Professor Abdullah, because when we first started off, the caucus that we had, we came together and formed our society from our houses. We have studied. We see the formation of ancient civilizations operating as ecclesiastical bodies. So we noticed that under ancient principles of law, a house itself is considered as a community. Once we understood this, we came together and formed our own ecclesiastical society. We went the way of ecclesiastical society because we knew the weight that ecclesiastical society have different from a social trust. Now, however, we We're not asking everybody to come together and form an ecclesiastical society. We know that there's a mass of people living in different communities, regions in Providence. Y'all need to come together and form a social trust. And that's why we recommend a constitution. When you do that, you're coming together as a population of voters. The United Rest Republic was created by us to put on the floor for all the government bodies that elect their representatives to form the Imperial Parliament Council. That would be the National Council for the national government. Then motions put in the floor, thanks Sister Tamara, that we had to make sure that we can't leave nobody out, no nation behind. So we decide that we have to come together. We have to decide and pass a resolution together collectively on the flag, the seal, and the name. Now, however, though, we have also, before the Constitution is signed, if you have one, you have to form a treaty. I mean, we have to form an alliance among ourselves. We have to let the rest of the world see our fist, that we together, we are packed, we impact. We're not nothing to be played with or joking, not through arguing, warring, but to actions, express and apply actions. That's the community want to see. That's what we trying to get the people raise their level of maturity in the mind, so they won't be making this mistake right here. Now I'm happy they didn't get hurt. There's other brothers out here that's doing fraudulent things because they feel as though I'm gonna do it this way. This is the way I want to do it, but that's not the way it goes. Don't follow them. I don't care who else in the world. If a person is not looking back to the principal foundation of jurisprudence, our culture, and the equity, mean the value that you take from that. If they're not doing that, I don't care who they say they are, don't follow. Because most likely they don't have a government. They claim to have a government. They claim to be an ecclesiastical body, but when you weigh them, look at the evidence. What's the evidence, Shem? You keep saying the evidence. The evidence is what I can go back and grab. That's already settled. Settled principles. We don't have to argue with each other. Let's just humble ourselves and let's look back and go by the settled principles. Not something 100 years ago, not something 150 years ago. Let's go back to what established all these nations living on our continent and our land, our territory. What gave them the right to be here? What gives you the right to be here? What gives you the right to claim your personal property, your estates? This is what we have to get. We got to get to the maturity where we got to stop worrying about everybody else, nation or people, and worry about ourselves. We haven't been doing that because we don't know. Nobody wants to humble themselves and say, you know what? I just don't know. When you could do that, you could be helped. Like Professor Abdullah said, we all was in that mindset. My mom was raped too. We all had the mindset about the Constitution, the state statutes, leaning on the Europeans. See, when you lean on a nation to protect you, you a refugee, people. If somebody protecting you and giving you asylum in your own land, they feeding you, taking care of your livestock, protecting your water, what do you think they doing? You're not doing it. And they educating the people so they would know how to carry out the functions of their Constitution. And they got a military and recruit your people to protect their interests and not your own. Now, you see why you have to have a population? You see why we got the Academy of Providence? Listen, I got born into this too. This is how it is. I'm just glad to be the number that I have a mind to look back, not look what we got right here. Oh, he said that. No. I don't want that. That never worked. When a man go to build a house or a skyscraper, you notice one thing he always do. He cuss and excavate in the foundation of the ground and put that foundation in. Why he go to the earth and put that foundation in? Because that's to establish the building so it won't fall down. He's putting a structure up. So that's what we're supposed to do. Go back to our ancient cultures and carve in that a government structure and get ourselves out of this. Go ahead, Professor.
Well, thank you, Shem. Thank you for that enlightenment. We want to let's continue. Let's play some more of this. We'll play some more of this. This is good analysis.
Todd McGee, former Massachusetts State Trooper, and Chris Swecker, former FBI Assistant Director. Todd, now, you know this group. I've never heard of this group before, but you know them well from your time as a state trooper up there. Now, what can you tell us?
Well, I think we first need to point back to sovereign citizen ideology. And what's important about sovereign citizen ideology is recognizing the recruitment tools and the propaganda that's used by the rise of the Moors and other Moorish groups such as this. And they will point to things such as the treaty dating back to 1777. I've also seen dates of 1787, which was a treaty between the United States and the country of Morocco. Well, what that treaty was about maritime laws for maritime that allowed privilege of the United States and the privileges for the Moroccan country, their maritime, to support privileges based on economic, not treaties for citizens, but economic reasons. Just like sovereign citizens will also use maritime laws in order to confuse law enforcement during motor vehicle stops. So we have to understand that they don't recognize themselves as sovereign citizens. However, their ideology is closely aligned to sovereign citizen ideology.
Let's stop there. All right, let's look at that. So let's analyze it. First, let's analyze who he is. This is called analytical skills. We're not talking about the nationality, whether he's Negro, color, black. I'm talking about his occupation. His occupation. All right, because he could have been German, French. His occupation. A state trooper, not a jurist. A state trooper, which means when say, well, state trooper, that means you have no experience and knowledge and study in international law. You have no experience and study and knowledge in treaty studies and treaty cases, analyze treaty cases. You have no experience and knowledge in international affairs. You didn't work in the State Department. All right, you didn't work in the International Court of Justice. You're giving, so he's being viewed, he's being misrepresented. But not, regardless of what his nationality is, he's being misrepresented as an expert, as if he is a jurist. And they're eating up whatever he's saying about his opinion. All right, so let's look at it. He mentioned the Treaty of Peace and Friendship of 1786. He talked about the treaty that it had nothing to do with citizens, but it had only to do with maritime. Here we go. We're going to look at, I'm going to read Articles 19 to Articles 23 of the Treaty of Peace and Friendship of 1787. Keep in mind, he said it had nothing to do with citizens. Article 19. As we'll start with Article 20. If any of the citizens has nothing to do with citizens. Well, he's a state trooper? Oh, he's a jurist. If any of the citizens of the United States or any person under their protection shall have any disputes with each other, the consul shall decide between the parties, and whenever the consul shall require any aid or assistance from our government to enforce his decision, it shall be immediately granted to him. This is Morocco speaking. This part, this is the United States. All right. regarding the protection that United States citizens will have. All right. If a citizen, Article 21, if a citizen of the United States shall kill a citizen, had nothing to do with citizen, all right? If a citizen of the United States shall kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place, and equal justice shall be rendered, the consul assisting at the trial, and if any delinquent shall make his escape, the consul shall not be answerable for him in any manner whatever. Article 22. If an American citizen shall die in our country and no will shall appear, the consul shall take possession of his effects, and if there shall be no consul, the effects shall be deposited in the hands of some person worthy of trust until the party shall appear who has a right to demand them. But if the heir to the person deceased be present, the property shall be delivered to him without interruption. And if a will shall appear, the property shall descend agreeable to that will as soon as the consul shall declare the validity thereof. Article 23. If the consul of the United States of America shall reside in any seaport of our dominions, that they shall think proper, and they shall be respected and enjoy all the privileges which the consuls of any of the nations enjoy. And if any of the citizens of the United States shall contract any debts or engagements, the consul shall not be in any manner accountable for them, unless he shall have given a promise in writing for the payment or fulfillment thereof, without which promise in writing no application to him for any redress shall be made. All right. So remember, this is state trooper. This deals with citizens. This deals with citizens. Article 20 to Article 23. So we can debunk that. But after all, he is a state trooper being misrepresented as a jurist. What I mean, no, they never said, he never claimed to be a jurist. So when I say misrepresented, because I just want to qualify that. He never claimed to be a jurist, nor did they claim that he is a jurist. However, they asked him for his opinion. He went on talking about the treaty, and his opinion about the treaty was taken as gospel, as if he were a jurist, as if he had knowledge of international law and experience in international law. A jurist would have never said that. They would not, if they had a jurist on there, a jurist would have never said what he said. Because a jurist is not going to go on TV in public and put his or her reputation online. A jurist is not going to go on. See, he can get away with that because he's a state trooper. He's a state trooper. So there's no repercussion because he's a state trooper. So he goes, well, he's a state trooper, so he don't know law anyway. He don't know international law. He's a state trooper. But if he was a jurist, they would hold him or her, a jurist. A jurist. Keep in mind, he's a state trooper. So whatever he's going to say is going to be dismissed anyway, because after all, he don't have experience and knowledge of international law. All right? Shem, comment?
Because the opinion that he gave is not founded in jurisprudence. It's not founded in Moorish culture, and it's not founded in equity. So he made an opinion based on him being in different what they say meeting the Moors on a expressway or the highway as a state trooper, coming in contact with them and traffic stops. That's basically what he's saying. He basically reciting what he went through as a personal experience on the highway, expressway, dealing with Moors who talks about treaty. He has absolutely no knowledge about the treaty, but he only go by his personal experience, which don't make him a jurist, which don't make him an expert on international law. This make him a man giving his opinion based on running across Moors, renegade Moors that's on the expressway driving without tags and stuff, and claiming to be Moorish consanguinity, and claiming the treaty, protection of the Treaty of Peace and Friendship. So it's not nothing that no one can use as authenticated. It's nothing proper. The concept is errorless because he's only giving a personal opinion. So that's just a personal opinion. That don't make you an expert. Personal appearance, but makes you an expert when you're educated and trained in that field. That means you look at volume of jurisprudence, culture, looking back at ancient cultures that led up to what this political organization that you are operating from in the international affairs, what gave us they outstanding, and how can we make a claim and protect our status and protect our interests and security while we're here in this foreign land, or while we're here dealing with other citizens, nationals in our country. So one other thing is interesting in this here is at the time when it was being arraigned. Now, when you go before a judge and you're being arraigned, that is the time that invoke your rights, your culture rights. I don't care if you was misled or whatever. This is why I say you have to be educated and you have to be taught on what to say, because you'll fall into the trap, tricks, and trade. You'll be going off like a surety. The bonds are already written. They looking at money. I'm serious. They're already up on it. They're already being used underwriting. They need the bodies. I want Terrence to go back to the arraignment, and I want y'all to pay close attention about what is being said. See, this is the part that you learn from. You can validate and verify. What are they saying? Why are they saying that if they're Moors? And I'm going to explain why. Go ahead, Terrence. Go back to Jamal when he was talking, the other, the arraignment, whoever was on arraignment. Even the brothers that's incarcerated, if they got a chance to see this can help them out.
Yesterday in what became a pretty chaotic hearing.
How can I get a probation? How can I answer these questions of probation if I've not been charged? I've not committed a crime. I'm not guilty.
I am not a sovereign. I'm a national. All right. You understand? I am not a 13th or 14th Amendment fictitious entity. I am a free Moor. I am a nationalist, a living, breathing man. I am not a fictitious entity.
I'm not black, I'm not Asian, I'm not Hispanic, I'm not Latino American. I am well within my constitutionally secured rights to carry and bear arms.
Let me stop right there. Now, this is the fact that the British European powers entered treaty with the Moors. If a Moorish woman operating the occupied jurisdiction of one of the crown, France, Spain, Great Britain, or for the best interest of all the European nations under one treaty, when they go into these different political organizations, a woman have a baby. When she have a baby, it's born in the political jurisdiction of the crowns. The woman never claimed a nationality, a political allegiance. Therefore, the child by native, they consider the child to be the political status and allegiance of the child is under the crown. Now, no, but they're United States citizens. No, they're not. United States citizens made it clear that a Negro has no part in their society. So you couldn't even hold any political allegiance to the United States because they say you're not part of their government. So how you part and partial of their government? They say that United States make that clear. A Negro is a Moor. So if a Negro or African descent which is a Moor. If you don't have any rights, or you cannot be a part of the state of origins or the United States, then that means by your mother having you, not claiming political allegiance, you automatically become a British subject, a British national. You heard me? United States does not have any jurisdiction. If your mother goes into a United States hospital and born you, you cannot be a United States citizen or a citizen of the state, watch him, because they made it clear you would not consider as anything a part of their society when they formed the Jubilee. Now, under Articles of Confederacy, yes, you could. You could be a national. Yes, you could. But not under the Jubilee. They made it clear. They even went far in the Judge Scott decision, saying by the Negro. And remember, they looking back to say this, that a Negro never had any status, any rights under this government. Now, let's look at that. Political allegiance. Your political allegiance is to the crown. You're a British subject. You're not British national. You're a subject. Because you are Moorish consanguinity, that makes you a national. And nobody's educating you on this. Nobody educate the mother on this. United States doesn't have any jurisdiction in Morocco. United States is a group of provincial colonies that was given a charter to self-govern themselves with a political national identity. That's it. So how can a Moor, let alone a Negro that can't be part of their society, how can the Constitution be, how can you be part and partial to that? Now let's examine this. He go a high court, make a decision based on their jurisprudence. And here come a man or anybody come telling you later on, disregard that. You part and parcel of them. Somebody's a fraud. Or somebody just don't know jurisprudence, like Professor Abdullah said. They don't know jurisprudence. I'm going to leave it, they don't know jurisprudence. They don't know international law. They're not a jurist. Because a jurist would say, well, if you say the Negro, that got the more. Because a Negro is a lower class, a low name, there's another name for it, and a more. So if a Negro doesn't have any, then what makes you think of more is part and parcel with that United States society? So we need to learn how to do is really read, and then let's examine all the concepts and opinions of other Moorish so-called leaders and educators. Once we read, we go back to read, and we go and use that evidence and put it against what they say, and then we can come to the right concept and not be misled. And then you have to say,
Let's give them the 5 United States.
yes. Professor Abdullah is doing is he's putting up the 5 United States. Number one, the United States, they first went to France, because France was the first one that they went to. Second one is the Lenape Moors. That's the treaty with France of 1778. I think it was in September, I believe. I'm not sure. The next treaty was the Lenape Moors, 1778. That's when the United States first established themselves as a political body. The new United States established itself as a political body. 1783, the Treaty of Peace and Friendship with Great Britain. And the other one was under the War Powers Act of Abraham Lincoln. Abraham in the South walked out on Congress. This Congress walked out on the president, and it wasn't a full Congress. There was a breach of the Constitution, the breach of treaty. That was 1760. Yes, somewhere in there, yes. 1863. And the next one was under Teddy Roosevelt, the New World Deal. That was Roosevelt revoked the War Powers Act and took the gold standard away. And he revoked the War Powers Act, creating another United States under the War Powers Act, which all the states rewrote their constitutions and became de facto. Trade the Enemy Act, absolutely. When the states was ordered to rewrite their constitutions and join the Federal Reserve Bank to be a national bank. All the states are national banks. And they became under the Board of Governors, would put them under International Monetary Fund and put them in control of the World Bank. Therefore, United States centralized the currency in one currency.
All right. Continue, Shem.
This is what we must understand what we're dealing with. We're dealing with a de facto corporate country. They're not de jure. I mean, they're not authenticated and legitimate. What you talk about, Shem? They're not operating on the principles of well-established laws when they're de facto. De jure only applies when the lower prosperities are threatened, their interests are threatened. Then they bring up the treaties. They're good boys now, as the Constitution applies, because someone of interest, private property. See, remember, United States can't claim to own any property. The private property is owned by the crown and the prosperity. That's the lords, the Herodian family successors. They always still have the property now. The United States don't own nothing. Please hear me out. They don't own not a stitch of land. 1763 proclamation dealing with buying land. They don't own nothing. When you hear the game saying French property rights to personal property, they run it like a Ponzi. Let me explain what I mean. In order to have a allodian title, you can have colorable title through occupation. That's why you hear the word grantee and grantor. You don't hear the word like vendor, buyer, purchaser. These terms are not in there. You don't hear deed by treaty. You only see that when a jurist is operating under international law. I mean, when a national government that has a treaty with somebody purchases a piece of land, the deed is done by treaty. It's put in the archives of the Ministry of Foreign Affairs. It goes there. The local records don't mean nothing. They get a copy of the website to validate that. But that deed does not go into a local record. It goes into the ministry. The ambassador seals it. So you see, we're dealing with, even in the title on deeds, or fraud. Because a grantor is a donor. So you know what? When the Rothschilds do a trust, you would never catch the Rothschild use the word grantor. Why would the Rothschilds use the word exchanger or truster or settler? Because they're the author, the creator of the instrument. The Constitution of the United States, I'm glad you brought that out and you proved it, that we the people are them families under that 1763 treaty. That's the barons, dukes, earls, and counts. And please hear me out, Moors. They wasn't Very low percent of them was Albanians and Albanos. Majority of them was mulatto people with more visible melanin carbon. That's what they hide from me. That's why they take the paintbrush and make them like they're Albion or Albano. What are you hiding? Tell the truth. Moors is over here as these kings and queens sign a treaty with Moors. So they send us on a wild goose chase. Go look over there. They're doing this. Well, you pickpocketing somebody, taking their wealth from them. They are pickpocketing us by the miseducation. They doctrinizing us. A fraud. Because they make you see people like us, we always run the world. We the ones signing treaty with you. Don't tell the truth. Let's stop lying. It's time to tell the truth. The Romans, the Roman emperors, the Greeks emperors and stuff, they was melanated, carbonated people with melanin, visibly conceived. Why you have to pay? Abraham Lincoln was a melanated man. You can visibly see his melanin and carbon embedded in him and as coal. Why would you take a brush and paint the man as an Albion or Albano? Because you hiding the power, even as under the label of Negro has been taken out of the contents. A Negro still have more clout than a United States citizen, even under the title Negro. So they paint a story, oh, they was hanging you. You wasn't talking about what they were doing to these Albions and these cervix over there, Eastern European, when they better on the ship working for us. Yes. We're going to go into the, Abdullah got a treaty case I want to bring up, and this one is dealing with a treaty dealing with land, personal property. The Moors don't know, they don't have a national political identity. And this is why when they go to make claims to do anything, they don't have a government, a country that they can say, I have a political national allegiance to this country and under that flag. And by making that claim, you got standing. Let's go to the case. Go ahead, Abdullah.
The United States Supreme Court. This is Colorado versus Oregon, 366 U.S. United States, 187, 1961. So tertiary to the Supreme Court of Oregon. 2 residents of Oregon died interstate, leaving personal property there and no heirs or next of kin except certain residents and nationals of Yugoslavia, claiming that the Yugoslavian relatives were ineligible to inherit such property under an Oregon statute. The state sued in a state court to have the property declared escheated to the state. Held an 1881 treaty between the United States and Serbia, which is now a part of Yugoslavia, entitles residents and citizens of Yugoslavia to inherit personal property located in Oregon on the same basis as American next of kin. And these rights have not been taken away or impaired by the monetary policies of Yugoslavia exercised in accordance with the later agreements between that country and the United States. The International Monetary Fund of 1944, to which the United States and Yugoslavia are parties, and an agreement of 1948 between the United States and Yugoslavia, coupled with the continued adherence of the United States to the 1881 treaty, precluded any state from deciding that Yugoslavia foreign exchange laws meeting the standards of these agreements can be the basis for defeating rights conferred by the 1881 treaty.
Okay, before you go into the highlight part,
Yes, I just wanted to
the
give
money,
the basis.
the monetary system of the money, the promissory note. Don't take away your most consequences or your national political identity if you're part of a Moorish state. It does not, because there've been already settled action treaties dealing with money system, dealing with bartering. So a country that does not have jurisdiction in a territorial land does not get to make any decisions. on the consequentity and the political status of a Moorish Moroccan. So personal property, we talk about, these talk about political occupying jurisdictions. We're talking about land through consequentity, through descent, kinsmanship, inherit, heirship. Go, Professor, read on, you can see it go along. That comes
Also, what keep in mind is that their presumption that we're not Moors. Like, well, that we're black identity extremists. You know, that oh yeah, Morocco over there. So they make an assumption that we're black, nigga colored, and that we're not Moors. All right. So what are they doing? They are usurping our divine and inherent right to claim our consanguinity.
right.
They're telling us who we are and who we're not. We say we're Moors, they say you're black. We say we're Moors, they say we're colored. We say we're Moors, they say we're African Americans. We say we're Moors, they say we're Negroes. We're saying we're Moors, they say we're Negroes. We say we're not United States citizens, they say we are. We say we're Moorish nationals, they say we're United States citizens. All right? Address that, Shem.
Yes, and the reason why they're saying that, because they look back and they look at structure. Structure is very important. A community, a population, voting, a political structure of buildings dealing with government buildings and embassy, government to government relationship, elections, media, elections held, somebody elected, somebody speaking out openly to the international community, people claiming to be a population, is not hid. It's well settled that this is what other nations are doing, and the people and the Moors are relying on the ancient structures, and they have someone to defend them in the international arena, I mean litigation. They have someone to file a complaint for them. They have someone to go to the parent against them. They have someone to bring claims against them. They see a head of state. They see a parliament having elections. They see a judiciary where they get subpoenaed to come to a Moorish court, like the 1856 treaty say. See, these are the elements of proof and evidence. So when they don't see that, first of all, they're not even educated. They're not even trained or taught what a Moor is. The only thing they know is they kill a dead history put in front of their face. And that's all they know until they see the executive power of the government and the people assemble take charge and build these. That's when you see, when they see, they know they've been lied to. When they see that you up there shaking hands and you at the UN the proper way, wait a minute. When they see that you got media on the street, that they see your posters up there saying this man, a Moorish election going down, they see a city hall building. I'm talking about in real time. This is government structure. Then you're able to go to the bankers under the Arraignment or other treaties and establish your currency under the Uniform Commercial Code coming from your political state. No one can throw you in jail now. The memo, the proclamation go out to the governments that notify all the police forces that there's a government. Listen, when this happened, then they get able to turn when they see a Moor driving their car with no tags. This is when they'll call you, and you step in and supersede intervention. So I got this. He's claiming Moorish consanguinity. That's a political allegiance to Moorish. I have to take this. You have absolutely no jurisdiction because he have not claimed political allegiance to the United States. United States don't have jurisdiction in Morocco. United States don't have jurisdiction over Moor to make a decision. So I have to take the jurisdiction. Then you have to arrest the Moor and take him in for questioning and investigation. until we get to that fundamental set of principle, which we're building to get there, and we're not far from there. If we all just stop backbiting each other and look to the principles of the truth, look back at the truth. Let's stop arguing about a man or a woman. Let's just let's just reason on the history of the flag, on the treaties. Forget about everybody else, on the old covenants of the seers. Let's just go there and let's stop right there. I guarantee you, when we do that, we're gonna see all these leaders, all these apothecated liars fall right in the bucket. They all fall in the bucket. That's when the scales fall off your eyes. See, right now the scales are on people's eyes. The moment they get illuminated and the scales fall off their eyes, they can see. Good, Nobles.
Hey, thank you, Shem. 2 residents of Oregon died in the state. I read this at top. Held. This is what it said to be read. So that's held in the 1881 treaty between the United States and Syria, which is now part of Yugoslavia. All right, here we go. Under the 1881 treaty, with its most favored nation clause, these Yugoslavian relatives have the same right to inherit their American relatives' personal property as they would have if they were American citizens living in Oregon. The International Monetary Fund of 1944, to which the United States and Yugoslavia are parties, an agreement 1948 between the United States and Yugoslavia. All right, so continuing here. Mr. Justice Black delivered the opinion of the court. John Stoich and Mohanurin Zerkich died in Oregon in December 1953 without having made wills to dispose of personal property they owned in that state. Their only heirs and next of kin who, but for being aliens, could have inherited this Oregon property under Oregon law were brothers, sisters, nieces, and nephews who were all residents and nationals of Yugoslavia. But 111.07 of the Oregon Revised Statutes rather severely limits the rights of aliens not living in the United States to take either real or personal property or its proceeds in Oregon by succession or testamentary disposition. And subsection, all right, so it's page 366, United States 189. All right, subsection of the same Oregon statute provides that where there are no next of kin except ineligible aliens and the deceased made no will, the property of the deceased shall be taken by the state as escheated property. The state filed petitions under this provision in the Oregon Circuit Court to take for itself the personal property of both decedents, alleging that there were no next of kin eligible to take under Oregon Revised Statute 111-070.070. The answers filed by the Yugoslavian relatives and the San Francisco Consul General of that country, so you know that San Francisco, I mean that is the Yugoslavian Consul General. They were just stationed in that British zone, San Francisco, of that country, who are petitioners here, allege that in fact and in law, reciprocal rights of inheritance as prescribed by Oregon 111.070 did exist between the United States and Yugoslavia when the decedents died, and that the Yugoslavian relatives therefore were eligible to take under Oregon law. After hearing in which evidence was taken, the trial court found that the reciprocal rights of inheritance required by statute 111.07 paragraph 1A did exist, and that both at the time the two deceased died at the time of the trial, there existed rights of citizens of the United States to receive payments to them within the United States of monies originating from the states of persons dying within the country of Yugoslavia.
Okay, now look what we have here: a political identity, a national political identity, and a government that has foreign affairs, that had a council stepped up and enforced the treaty rights. See, what I'm showing the Moors that's being a little afraid, they're scared, they see this stuff going on. Look how they claimed a national political identity and had a government country to back them with a council. You see what we lacking at? These are the fundamental principles that we have to deal with. We have to get here. That's what we're building to get at. To get the Moors here. You don't have to be scared. Ain't nobody gonna do anything to you. Just claim. But you have to come together first. If you can assemble and go out here and give out flyers and put up stickers and banners for a government that say that you won't have a part of, and you tell me you can't come together, it's simple. Nobody gonna beat you up. Just assemble among yourself peacefully. Have meetings. Find out who's the jurors and the drafters and draft. Let the people look at it and say we consent to it. And then let their representatives say you sign that because we agree to that. And form a constitution and form a treaty among yourself. And that's what we're doing. Then when the same thing happened here, when you have a problem, the council can step up and say, the Moorish government have original jurisdiction. You don't have any jurisdiction. You can't even make a decision. You have any jurisdiction in Morocco. You don't have no jurisdiction at all in Morocco. This matter is taken to the Moorish court, the head of state or the Mufti, the judge. If a Moor gets locked up, the council files the paperwork to get it to the Moorish court. Then he steps out the way because he can go in and out the foreign jurisdiction because he got immunity or she got immunity.
Shem, can you speak to the mixing? There's been a confusion in this Moorish movement, about this mixing, and we even you were hearing the tape in the recording where Jamal is claiming that his rights to bear arms comes from the Second Amendment of the United States Constitution. They holding up the Moorish flag, because I can see that how Albions and Moors who don't know they're Moors could be a little confused, can be a little off, because they holding up the Moorish flag and they're saying that they're Moorish nationals, but they're saying that they're claiming that their rights to bear arms comes from the Second Amendment of the United States Constitution. I can see how that's like a quandary. It's a little confusion for people who don't understand. How can they claim to be Moorish nationals and hold up? So what does this Moorish flag mean? Why are they holding up the Moorish flag? Well, let me finish here. Someone would ask, why are they holding up the Moorish flag? Why aren't they holding up the Star Spangled Banner? Why aren't they holding up the Star Spangled Banner? Because they claim that their rights to bear arms come from the Second Amendment. They should have held up the United States banner.
Absolutely.
Absolutely. All right. I'm saying
that's true.
My rights to bear arms My rights, Jamal should have done this. My rights to bear arms comes under the Second Amendment of the United States Constitution. Then the list, then there'll be there won't be confusion. There won't be a confusion there. But when you do this, my rights to bear arms comes from the Second Amendment of the United States Constitution. That's a confusion.
Absolutely.
I mean, we have to address that. This is very important because Jamal did not hold this up. And I myself was under this confusion. I have to admit that. Thank you for bringing me out of the dungeon of confusion. And a lot of Moors, those who know their Moors are out there were under this confusion. Thanks to the Academy of Providence for bringing them out of the dungeon of confusion. And there's still Moors who know their Moors under this confusion. All right, so I speak to that, Shem.
Yes, he's confused, and at the same time he's unfair. What I mean is that he's to expression and apply contracts. His allegiance is under this flag, but he's looking to claim his Moorish consequentity under this. But what he failed to realize is that his Moorish consequentity is by birthright before the symbol of this flag was created. So this flag is a political banner that you seek protection under a identity. That means you from a state or nation that's operating in the territorial jurisdiction under this flag, and therefore you're protected by this flag. So when you hold this flag up, that means you're claiming that it's a nation or state, a political body that you have a national political allegiance to, and that you fall under this flag, which the nations under this flag collectively sign treaties with these foreign European powers. But expressly and applied, when you start talking about the Constitution and its political jurisdiction, then you claiming political allegiance to this flag right here. You only throwing this flag up because you don't have the knowledge while you're doing it. Lack of knowledge.
I was one of them. Everybody, I have expressed that I was one of them. I really was. I honestly have to say that I was one of them. I can clearly see now that the cloud of confusion is gone, and I thank you for that. I humbly thank you, brother. I thank you. All right. I thank the Academy of Providence, all right, for providing an educational model and venue. All right, Tamron, Il, and I, founders of the Academy of Providence. So we have, has also been stated, Shem, that a Moorish consular court is an Article 3 court under the Article 3 of the United States Constitution. A Moorish consular court is an Article 3 court under the Article 3 of the United States Constitution. Speak to that, Shem.
No, that's not true. That only allowed the United States to hear cases when they are a party to the treaty, based on it, if it's self-executed, and the treaty stipulates a legislative act to bring the treaty into force, operation into under alienation. Not only do the United States have the obligation, but the other signer has a right to pass legislature to put the treaty into force. It's just not the United States, because the United States is not just a signer to that treaty. So if they're not self-executed, it's not just on the United States to enforce that treaty. The other government have to pass legislature to force their rights to that treaty. Now, if a treaty is self-executed, That means it needs no legislative act to go enforce. It speaks for itself. It is red judicata. It's a stopper. Nobody can make it. The courts can't make a determination. Now, Article 3, Section 2 allows the United States to hear matters dealing with diversity of citizenry between the states, or something individual rights to be enforced by through treaty. The United States signed a treaty, and the treaty, it allows the individual of a foreign government or national citizen of a foreign government to force his rights in the court. That means he can bring his rights in the court, and United States have jurisdiction to hear that. Now, when it's dealing with a Moor, the Moor has original jurisdiction as a defendant. That's number one. If the Moor's court take original jurisdiction and the United States or the state of origin or any of its subsidiary counties or townships or shelves default, the consul or the judge of the executive branch ministry will stamp it as a default, or the mukti, the judge, will enter into a default. Moors, it will be certified, and the Moors consul will endorse it because it got to go into a different jurisdiction, a political jurisdiction. The consul then files in a court, the United States Supreme Court, that has original jurisdiction to enforce the consul seal based on legislature passed by Congress and the statute dealing with evidence. It say anytime a consul seal appear, it is the only prima facie evidence that's considered before the court. So United States Supreme Court would take that as prima facie evidence, and they will look at the consul seal and they will file a mandamus to enforce that consul order. So if someone is incarcerated, they have filed a writ attached to the default. The consul can enforce, the Supreme Court will enforce the writ of habeas corpus. The consul will take it before the Supreme Court, who has original jurisdiction. No circuit court or lower court, consul should be not funded. Neither of these courts. The United States Supreme Court has original jurisdiction dealing with aiding a consul or foreign minister or ambassador. When a consul goes there, the Supreme Court, the writ is already issued. The Supreme Court is now will insist the consul by having the marshals release the party based on treaty, international law. That way the United States to fulfill the international obligation. That's the United States operating de jure. A de facto United States will have to even take that, but they're looking at the Moors not getting that far. You're being educated now. So we're showing you how government-to-government relationship is being done, should be done, and diplomatic channels are open. Go ahead, Professor.
Yes, we want to address another misconcept that Moorish consuls of Morocco, that there are those who are claiming to be Moorish consuls of Morocco. Now, I don't recall there being a Moorish national election. I mean, does anyone recall there being a Moorish national election since our fall? Last year, 5 years ago, 10 years ago.
De facto.
All right. Who's the Moorish head of state? Moorish Bey or Day, Moorish prime minister. I don't recall there being a Moorish Day, or there's a Bey or prime minister or sultan or emperor. All right. I don't, because most of our people are unconscious. So I don't. You speak to that, please.
Yes, this government de jure, this government de facto. De facto mean when the people take it upon themselves to become illegitimate. They do something outside of well-settled principles of law, culture, and positive law. Jurisprudence, which is established, and the value, equity, the value. It's value in the decision, decrees, adjudications, and treaties. Once one does not take into account the legitimacy and the authenticity of them documents that was signed and was done by government, and they take it upon themselves to say, hey, listen, I'm doing it this way. That's called de facto. That's illegitimate, and that's illegal. So you operate in an illegitimate, illegal capacity, meaning that it holds absolutely no truth, no force, no power, authority, or delegation authority. This is why they can ignore it, because they can pull out the equity and jurisprudence and look to that and say, this is nothing. They de facto, so they know you illegitimate, so they can write you right off. We need a structure where we can write them off when they like that. But the thing about it, they're not operating like that. They still having their elections. They're still having their voting, their campaigning, their executive, their legislative, their judiciary, their ministries. They still have the structure because they're educating the people. That's the inherent. You hand it down through education. Then you give it to the people mentally. They inherit now the wisdom and knowledge of the philosophers, which is in the universities and the schools. Therefore, the longevity of the legacy of that government people could last. We not operate that way. We operate de facto. Anything else?
It means self-appointments.
That's right.
So I've just a lot of self-appointments. All right, there's a lot of self-appointments. What do you claim? What is your? Let's talk about. What you want to go? You want to go to this case here, Shem?
Yes, dealing with the charters. The charters.
We have.
Oh, okay. Yes, we're gonna finish. We're gonna finish going into this. Open that up to the end so we can finish that out. You start right from where you was at. It'll make a difference.
It's very bizarre. Well, Chris, here's what one of the men said about their supposed rights.
We operate in law, and we don't break the law, we're not against the law. We have the right to travel as a well-regulated military / militia, with the right to having no tags, no licenses, or no registration.
Chris, again, I think most people are just shocked by this. Also shocked, but maybe not all that shocked that the media gave it a pretty much of a big yawn over the weekend. Again, what do Americans need to understand about this?
Yeah, these groups emerged in the 90s, different iterations of the Moorish nation, sovereign nation, what have you. I dealt with them when I was the head of the FBI in North Carolina. They don't recognize any authority whatsoever, but they're basically a criminal organization or a set of criminal organizations that wrap themselves in some convoluted political ideology, basically to justify committing crimes. And the crimes they commit, they're prolific fraudsters. They'll take over someone's home, file quitclaim deeds, and then move into the home while they're not there. They commit tax fraud, file false tax returns. They've killed over a dozen police officers since 2002, in particular in Baton Rouge, Louisiana. One Moorish nation individual killed 3 officers and wounded 3 others. So they present a clear and present danger to law enforcement, and nobody should take them lightly. They aren't some benign political organization. That's just a facade.
And Todd, another member.
You let it play.
Spoke about what they claimed were their travel plans.
Our vehicle is full of camping equipment, which supports what I said about how we're going to our private land to train, which is our Second Amendment right.
So, Todd, what kind of training are they doing? And they seem to both cite the Constitution and then kind of claim they're not really beholden to any laws that are passed constitutionally. So it's a very odd dynamic. They're kind of picking and choosing what they will be held accountable by and to.
And that's the argument. They say that they are not anti-government, but to Chris's point, they skirt around with their language, their ideology. They will make reference to that they are independent of the law, not anti-government. To me, if you're not following the laws of the U.S., then you're anti-government. But regarding the ideology as they would speak to traveling, they say it's their God-given right to travel. That's why they don't need driver's licenses. So again, they split hairs. They find this way to manipulate words and make the words basically justify their actions. What we're seeing with the social media, the flag, and all these different things, this is going to be a propaganda and recruitment tool. So they're absolutely going to use and leverage this to gain other people and interests. Now, we don't know how many are out there. There are conflicting numbers, but watch and see the level of interest that this most recent incident over the weekend will gain the attention for the rise of the Moors.
Well, Chris, we've heard a lot from our FBI director, Christopher Wray.
Okay.
All right, we're gonna go right into this, Shem.
Yeah, the case, you go to the case with the Charter of the Crown. That's the next case I sent you. That was talk about the Charter of the Crown. That
This case here,
yes,
Martin versus Waddle.
yes.
All right, Martin versus Waddle, 41 United States, 36/7/1842. All right, error to the Circuit Court of the United States for the District of New Jersey. Ejectment for 100 acres of land covered with water in Raritan Bay in the township of Perth Amboy in the state of New Jersey. The land claim lies beneath the navigable waters of the Raritan River and Bay, where the tide ebbs and flows, and the principal right in dispute was the property in the oyster fisheries in the public rivers and bays of East New Jersey. The claim was made under the charter of Charles II to his brother, the Duke of York, in 1664 and 1674 for the purpose of enabling him to plant a colony on the continent of America. The land and controversy is within the boundaries of the charters and in the territory which now forms the state of New Jersey. The territory and grant by succeeding conveyances became vested in the proprietors of East Jersey, who conveyed the premises in controversy to the defendant in error. The proprietors, by the term of the grant to them, were originally invested with all the rights of government and property, which were conferred on the Duke of York.
Excuse me, stop for a minute. The proprietors are the ones that wrote the Constitution of the United States. They send the esquires, which they granted lordship to the esquires. That's we the people, that's them. What they did was allow the bar to create a charter, a new charter, that will allow the people to be submissive to them through that charter. I mean, let them have the elections, let them cry and whine and all that, but we still control them because we still own the personal property. We own the land. And this is what the people need, the Moors need to understand is that United States does not own any land. Nobody that's elected by the people of the United States, all these prosperity people here, the Lord, they had nothing to do with that. So when it comes down to title the land, these are the ones that call the shots. Not the president, not Congress, not the courts. The courts are quoting this as remember, they look back at the jurists. They go back to the history and be able to make this opinion. So you know who the United States, when it said the 13 states became the 13 colonies, well, they was leasing. The treaty allowed them to operate and carry the franchisor name. They became a franchisee by having the name Pennsylvania. So that means anything that they enter into under them names as United States of North America, United States, Pennsylvania, Delaware, all the way up to Maine, they are part of the crown. They are part of these prosperity, the ones that own the land, the personal property. Their allegiance is to them first. The people have allegiance, political allegiance to the Constitution. Now, let me understand. So those people, all the people born in all the states here, Delaware, all of them, hear me out, are British by origin. They subjects of the crown. No, they're not. They're independent. They run a war. That's not what the Crown say. Anybody born in Her Majesty or His Majesty dominion is a British subject that does not have a political allegiance to a foreign country. United States is not a foreign country. They don't have any land. They're occupying a portion of the Earth's surface as a political body. Under international law, they're occupying a portion of the Earth's surface. That's why they call it a country. Go ahead, Professor. I'll make sure we know this.
Now, keep in mind, this is 1842 case. This is 1842.
Right?
This is being discussed in a case.
That's right. That's right.
1842. I just want to emphasize that. All right. Afterwards, in 1702, the proprietors surrendered to the crown all the powers of government, retaining their rights of private property. Retaining their rights of private property.
Where you going? Let me explain what this means. When the crown ceded jurisdiction to the United States, they did not give up private property. That's why the United States don't own any land. The crown never gave them power and the ownership of the land. So what the crown did was ceded jurisdiction for them to operate, take care of some of the burdens off their treasury and put it on their back because they owe them a debt. And then it took the people and put them as a debt. Then took the Moors and miseducated them and made them a surety to pay their debts to the crown. All this wealth goes to the International Monetary Fund, the World Bank, and pay off all these for Pope. Everybody around the world living luxury, living good. Cardinals, royal families, they're getting a new lease. They don't have to even work. They're getting $7, $8, $9, $10, $100 million a year off of us, our back over here. And they're not telling the people. Go ahead.
All right. The defendant in error claimed the exclusive right to take oysters in the place granted to him by virtue of his title under the proprietors. The plaintiffs in error as the grantees of the state of New Jersey under a law of that state passed in 1824 and a supplement thereto claimed the exclusive right to take oysters in the same place. The point in dispute between the parties depended upon the construction of and legal effect of the letters patent to the Duke. Let me read this again. The point in dispute between the parties depended upon the construction and legal effect of the letters patent to the Duke of York and of the deed of surrender subsequently made by the proprietors. All right, that's it there. All right. The right of the King of Great Britain to make this grant to the Duke of York with all of its prerogatives and powers of government cannot at this day be questioned. The English possessions in America were not claimed by right of conquest, but by right of discovery, according to the principles of international law, as then understood by the civilized powers of Europe. The Indian tribes in the New World were regarded as mere temporary occupants of the soil, and the absolute rights of property and dominion were held to belong to the European nations by which any portion of the country was first discovered. The grant to the Duke of York was not of lands won by sword, nor were the governments and laws he was authorized to establish intended for a conquered people. The country granted by King Charles II to the Duke of York was held by the king in his public and regal character as the representative of the nation and in trust for them. The discoveries made by persons acting under the authority of the government were for the benefit of the nation and the crown, according to the principles of the British Constitution, was the proper organ to dispose of the public domain.
You notice they say country. What would they talk about? Why is New York called an empire state? The Duke of York and his successors and his kinsmanship heirs are the one that own the bridge, the skyscrapers, all that directions are on the Duke of York personal property. Therefore, he gets a what? He has a right to an interest that's called lease. And all the billions and trillions of dollars made there in trade goes directly into that royal account, which they break down. They live in good. That's how they worth $17 trillion. How did they get their children $1 billion when they graduate college? They don't hurt their pockets. Because they children, it's their descent. The problem with us is we've been miseducated. We have not learned how to inherit nothing. The first start of it is education. What you and Tamara did, that's good. That's how you inherit. That's how we get the people back their inheritance, by teaching them and educating them. Then they can make a claim to, they can say, wait a minute. We was here before them. What about us? Absolutely. We can make the same claim and come back. See, no one wants to say this. An Indian, when they got here, they knew the difference between the Indians and the Moors. This is why they would never talk downgrade on the Moor like this, but they would talk about an Indian like that. So you see what's going on now? They would talk about an Indian like that. They won't talk about a Moor like that. This is why in the international community, the Moorish treaties have never came up. Only thing came up in the international community by dealing with Indians was the Gantt Treaty, because it was a British interest was compromised, and I have it. I'll let y'all see it later. It had the United Nations is talking about the Gantt Treaty, and it's saying our states was already at the war was supposed to release. The United States didn't want to do that. This is why they have to keep using the word Indian, because they're looking at Indians as the occupiers, not the sovereigns. See, brothers and sisters, please listen to me. They're using constructive language like this man is saying to take they're calling you a savage. Come on now. You don't have any rights, title rights. You are not the indigenous and aboriginal people they're talking about. That's the Moor. Nowhere is the Moor ever talked about as a savage. In no old documents, a Moor is called a savage, an occupier of the land. When the French went to submit their authority, France said, we need evidence so we can win here. We need the people, the lowly titles of the land. They said, we're the most favored nation clause. We were dealing with the sovereigns. The lowly titles, they say more. Moorish treaties was called in play, not Indian treaties. Why? Because if you read the Camp Home Treaty, it said, it called the red man name, and it called the Indians. Say it called the Moors by the nation. Didn't have to say more. But when it say, and they associated band, the Indians, that means that the Indians are not the Cherokee. They're not the Choctaw. They're not the Wichita. They're not these names of the Iroquois Confederacy. They are the associated band of these people, and they was occupying the land, and the Europeans knew that. So they went to them to say, we'll go to them so we can strip title from the Moor by putting them in the place of the Moor as if they the one that had a sovereign power, but they didn't. This is the track, trips, and trade that we got to educate our people on. Anything you want to add, Abdullah?
Let's look at those in rebellion to the crown. All right, go into that. Go into the 1778 treaty between the British subjects in rebellion to the crown, British crown, and the Lenape Moors.
Well, it wasn't the way they said it. There was an in-house fight between the lords and the crown. That's the in-house fight. They used the people. That's bullcrap. No, it wasn't that. How you know, Shem? The people rebelled against them, and they forced the crown to get involved. So there was a difference between the lords and the crowns and dealing with the people. that happened, the Lords had see nobody could negotiate with the Lenape Moors unless it wasn't the common people. Please, it's not when the common British subjects. These was the Lords, the esquires that was on the out with the crown, had to flee for their life. And what happened is they took the people with them because they needed the people to be the pawns to fight the war. Remember, they were fighting the wars on behalf of them. The Lenape Moors sat down with them people and entered into a treaty and gave them asylum and gave them amnesty. The common people just pawns, just fighting the war. They disposable. They weren't nobody. They were just subjects. They just went along with was ever affordable to them. They were being told that they'd be elected because the people did have a problem with not electing their parliament, making their laws and electing their government. They did have that problem. But there was a splitted house. And it boiled over to the people. The people fought on behalf of the Lords. So that's the first United States that was given political asylum and amnesty to become a united colony in that territory. There wasn't the United States or provincial colonies that was established by Great Britain. There was new political organizations created under the authority of the Treaty of the Lenape, 1778, and that's when they created the Articles of Confederacy, was their constitution. The Articles of Confederacy was their constitution, and their delegation authority to exist as a government was that. This is why they use the eagle in the pyramid, because that's showing the existing government under Lenape. The eagle, the area core, and the pyramid, the mound builders. So you ask yourself a question more. Look at constitutions of nations. This is why the flag is not platinum. The flag is not platinum, neither is the seal platinum as the emerald. Now, me, Professor Abdullah, and Tamara looked at that, and we realized we realized it, and then Tamara went further and did the research, and she realized that they're using our national symbols to establish their authority as a government that exists on this continent. And they're using the crown flag, provincial colony flag, that they're under Great Britain. That flag. That's why they couldn't copyright that flag. It belongs to the crown. They use that flag, that banner, to show that they are partial with the crown. As a provincial colony, that never changed. New Jersey, Pennsylvania, Ohio, Georgia have the Lords. The royal family controlled the land as the benefactors. The people are just mere citizens, members of a occupying corporation country that is doing political business, the industry there. They don't own nothing. They signed a treaty, the United Mexican States, United Moorish States, Mexicans and Spanish speaking more. They signed a treaty with them. How could they sign a treaty with them under the United States of America? Because they were using the charter name. So when they signed the treaty under the United States of America, automatically brought in the private interests of the Lord Prosperities. It took over. They're still running everything. So Oregon, Texas, all that. Oh, Texas is a free state. Stop lying to the people. They're controlled by the French, Spanish, and they never lost their interest in the French and Spanish zone. Mexico have claimed a political status under the French-speaking name Mexico. Morocco or Moroccan has been changed to Mexican. American. Somebody said, what is American? American is anybody born. Hear me. Anybody born in the British, French, or Spanish dominion is an American. A Moroccan is one born in the territorial original jurisdictional land of Morocco, a province or nation or country in Morocco. That's a Moroccan or Moor or Moorish. An American means you're a British subject. You born in the British dominion. Anything else you want to add, Abdullah? Yes.
Tamara has a question.
I have a comment and a question. It feels like a propaganda. Well, first of all, thank you for analyzing this entire news broadcast, because we know the power of the media. And this is like a well played out 243-year propaganda display to keep the people in alignment with the, you know, the British Empire rules. So basically, you know, you're fighting for the crown, not unknowingly. The people are fighting for the crown unknowingly. So when you have ones that understand the difference between the British Empire realm and the Moroccan Empire realm, it's like we're going to do everything that needs to be done to keep the rise of the Moroccan Empire from coming back up. And you know, and it's amazing that you talked about the 1778 treaty with the Lenape Moors. This distinctively showed that these individuals that we see today, that's in the news, broadcasting, news, print, visual, all that, these are the direct descendants of their forefathers that came upon the shores as colonists to be able to farm, fish, to be able to for survival, for their lineage.
Subject, that's right.
And so 243 years later, they are portraying as if they are the authors. They're as if they are the original of the entire Almagred.
Yep.
So they're playing this well played out role to where they're upholding their forefathers constitution. So let's analyze that. Can we look at how the current the current British the heirs, the descendants of the British forefathers that came over to set up colonies, let's analyze how, you know, that within content of itself is playing out today on the screen to keep our people from realizing who they truly are.
Oh, what it's because of the indoctrination that's in the schools. We had the Egyptian New Year, which is July 4th. And on that day, it celebrates that United States won its independence. You know, drum beating. So that is a misrepresentation right there. That is a grave misrepresentation. That United States is independent from Great Britain. They won the war. They free. They separated from what was called their mother. So that's look, and that is reinforced July 4th, every July 4th. So let's examine that there. Now, in looking at one of the misrepresentations is that Great Britain has no interest here anymore. There are treaties, the Society versus New Haven, 1794, clearly indicates that is not the case. In the Society versus New Haven case, 1794, that case where the Society that propagated faith, and in Virginia again, and so this dealt with, well, this society, or actually New Haven, Connecticut, and this society, and the treaty indicated that the Revolutionary War did not extinguish rights prior to the war. And that was a major, that was one of the first cases that dealt with treaty, that really brought to life that treaties are the law of the land. And so this misrepresentation that the United States Constitution is all so powerful and the law of the land, and no other law exists above the United States Constitution, that is not the case. United States Constitution is not the law of the land. The United States Constitution does not supersede the 1783 Treaty of Paris between the United States and Great Britain. United States Constitution does not supersede the 1778 Treaty between the United States and the Lenape Moors. United States Constitution does not supersede the the case dealing with the Society versus New Haven that dealt with the 1783 treaty. The United States Constitution does not supersede the treaty between the United States and Great Britain, 1795, called the Jay Treaty. The United States Constitution does not supersede the treaty between the United States and Great Britain, 1814, the Grant Treaty. The Grant Treaty, the United States Constitution does not supersede the 1787 treaty between the United States and Morocco. The United States Constitution does not supersede the 1796 treaty between the Bay of Tunis and the United States. The United States Constitution does not supersede the treaty between the Dey of Algiers and the United States, 1797. So these cases, if you examining these treaty cases, these well settled, looking back, so the United States Constitution has been misrepresented as this all-powerful supremacy above any other. It's been misrepresented. Speak to that, Shem.
Once again, I want Professor Abdullah, before I speak, to go back to that paragraph up there about the Lord. This is what we need to learn how to do. Read, like Tamara said, she looked back to jurisprudence and positive law and equities. I mean, read and validate and verify what is being placed on the table now in front of you. That's a good concept. I'm glad she said that to me. Don't just tell them that they be educated or learn, but say, read it, and then use it to validate what you're learning on now. Now we're going to read the ones where Professor Abdullah say, we're going to read to show you that they don't own any land. We're going to read to you ones who own the land as the benefactors, the Moors and these people here.
All right. The claim was made under the charters of Charles II to his brother, the Duke of York, in 1664 and 1674 for the purpose of enabling him to plant a colony on the continent of America. The land and controversy is within the boundaries of the charter. Within the boundaries of the land and controversy is within the boundaries of the charter and in the territory which now forms the state of New Jersey. The territory in the grant by succeeding conveyances became vested in the proprietors of East Jersey.
Stop right there.
Now, let's stop there.
That's not just only East Jersey. William Penn was granted this. William Penn was granted the same thing and created Pennsylvania. College, the state governor building, the counties, all are the possibility. William Penn get the revenue. The Penn family can step in and make their grievance to the British royal court and say that the British constitutional rights are violated. And that supersedes the United States constitutional rights. So you see all these states and new states that are created are all under the lordship.
Let's look at this though. And look, Shem, and looking at these over the past 2 years, Shem, I've been reading a lot of treaty cases, and I've learned a lot in reading treaty cases. Society versus New Haven, Ware versus Hilton, Hausenstein versus Lindheim. You know, even we would be reading tonight, Martin versus Waddell, 1842. You learn a lot with these, analyzing these treaty cases and these treaties, that the United States Constitution is not the supreme law of the land.
Absolutely.
I mean, that's something that we can clearly prove that the United States Supreme Court doesn't say that.
That's right.
In these decisions. So this is study treaty cases, because the treaty cases are written by jurists. And then Society versus New Haven was the first one. And looking at how long the case is, and wow, and and referring to other cases. And I'm like, wow, this is very wild. Even the 1952 case in the International Court of Justice between the United States and France, were 3 types of treaty that was used to adjudicate that case. And you see the volume, the decisions, and how well written and jurists put these together.
Yep.
So we're reading cases written by jurists, and they go into the history. And wow, I highly recommend. And we've been pushing. We've about what, over 30 treaty cases. Over 30 treaties, and including, in fact, the treaties that I have in my book, Moors of Masonry, have been brought more to life for me.
Yep.
All right. So we even and one of the courses, one of the cases, the class that we recently had, the Juris 201 class, where we reviewed the treaties that I have in my book, Moors of Masonry, in class 5 of the Juris class 201.
And to bring up, we talked about, Professor Abdullah, me and you re-examined the Grenada Treaty and found out that Moors still have original jurisdiction on Grenada over their disputes. And they land, they fishing, they control.
Yes, the Guadalupe Treaty.
Yes.
1846. Yes. All right. Tam, you have another comment, question? Anyone?
We open up for questions right now. It'd be good.
No, we're not. We have just 5 minutes left.
Okay, I didn't know that. Okay.
All right.
Anything else you want to add, Tamara? Terrence, Moors, and House. Any questions?
All right.
Viewing the news report that the former FBI, I can't remember his name, he really tried to paint the picture that us Moors, I mean, talking about all of us, not just talking about just the rise of the Moors or, he tried to paint us as if we're all criminals. Oh, it's a criminal organization. And can you address his viewpoint, or can you address that according to what Moors do when they, do their, do those actions or whatever? Can you
He's
address
not a
that?
jurist. That's number one. He's only basing it, like the state trooper, on personal experience that he dealt with people with melanin and carbon. See, people with visible melanin and carbon, he's only going on an opinion of him making drug arrests, violent gang wars of drug turf with people of melanin, visible melanin and carbon. He's only giving a personal experience.
Talk about Moors, conscious Moors.
Conscious Moors. He never ran across a conscious Moor. He never ran across a government. So he's making an opinion on us being as under the title of Negro, even though we say we Moors, of consanguinity.
What he did mention, though, is that Moors claiming people's houses. Moors claiming people's houses. He made these examples. These examples he made that Moors, filing fraudulent tax returns. All right, Moors claiming houses when people are in them. All right, let's speak to that. Speak to what he said. All right, Moors. There was Moors. 12 cops were killed by Moors. All right, we're talking about conscious Moors. Those who know they're Moors. That's what he's. Those who know they're Moors. All right, he's not talking about Moors classified as Negro, colored, black. He was talking about his experience dealing with those who know they're Moors. Those who fly this. Those who fly this Moorish flag on their car. This is what he's talking about. Those Moors. Speak to those Moors that FBI agent, and he was the head of FBI in North Carolina. Speak to that. That's what Terrence is talking about.
Once again, he's speaking on his personal experience dealing with Moors that's considered themselves part of Morocco. And he's looking at Moors that's under wrong concepts. These are Moors that's not operating on the principle of government-to-government relationship and a balanced Moorish paradigm. These are Moors that are operating, and I'm not disrespect, de facto. And they are Moors by consanguinity, but there's no national political allegiance, identity that they have. So he's dealing with Moors that considered de facto. And by making that assumption, he's making it based on not dealing with government structure. Moors that's coming from a national political identity. Moors that got a relationship under a title name government that has a head of state, has a parliament, has elections, has a media, has doing government relationship. He can't give an opinion on that because he had never ran across none, neither was he educated. So he breached over broad because he did propagate some of the things that these Moors have not done. See, this what happened when you operate de facto. You get somebody an open door to do all this stuff, to talk all this garbage. You open the door to let them throw garbage in your house. This is why we have to get political structure. Until we get political structure, this is going to keep going on. Abdullah?
Now, thank you for that, Shem. That's what we were looking for. Thank you for that, because we need that answer was right on time. Right on time. You know, and I definitely have to agree with you on that. Yes, Tamara.
One last thing in the analysis, there was a statement made as to why the FBI is not taking this Moorish movement of Moors that are breaking laws. Why aren't they taking this further or serious? Also, add to the point, he stated, why would the Southern leadership, what are they called? The
poverty.
Yeah, Southern Poverty Law
Center.
Southern
Poverty Law Center.
Southern Poverty Law Center.
Yes.
Why did they change the branding from sovereign citizens to anti-government? Why didn't they just stick with labeling us as sovereign citizens? So could you speak on those 2 points? The first point, let me just reiterate the first point again, was why the federal government is not hammering down on us, on Moors more.
Now,
and the second point is why the Southern Poverty Leadership Center decided to change our branding from sovereign citizen to just anti-government.
Okay, let me say something. A citizen born in the state has the same status as if their ancient mothers and fathers came off a ship.
Speak to that. Speak to.
I'm going to speak. They're in the service to state. They can't be sovereign citizens. This is why they corrected. A Moor that got a national political identity is a sovereign national. He's sovereign because he comes from a country, a most favored nation country. So to keep that title on a Moor will be true. They cannot have it whereas though if someone look further down the line and dig, they will prove that they are sovereign. So they rather call them extremists, anti-government, meaning they're against the government, meaning that the Moors are at war with the United States. They're attacking the United States, which is a violation of the treaty. You got to see the tricks, traps, and trades going on here. By making that statement publicly, you're telling the rest of the treaty nations that the Moors are down here rising up, killing our law enforcement, hurting our people. That means the Moors they're not operating in government. They're de facto. But to call a Moor a sovereign citizen won't be wrong. Because a Moor is a national. He's not, let's get this right. There's no treaty of Great Britain. There's nothing stating in any treaty or document that a Moor, Moorish or Moroccan, is a subject of any crown. That means he's sovereign. Show me a document where a Moor or Moors is considered a subject or called a savage. I'm waiting. There is none. So they're sovereign. The only problem is they have not created government that claim a national political identity. Once that happens, it's over. Checkmate.
I agree with that. I agree with that.
But the citizens was error to call them sovereign citizens because they can't never be sovereign citizens. The people that's living in the state as citizens, members of the United States, corporate country
They can't be. That's
cannot be called a sovereign citizen. The sovereign is the crowns and their royal Herodian bloodline. They're the sovereigns. The other ones are just some commons. The word common. Go ahead, Tamara.
all right. So we have the Academy of Providence has an upcoming course, Getting to the Roots. Getting to the Roots 201. 7 weeks course every Saturday from 12 p.m. to 3 p.m. Eastern Standard Time, starting July 24th, right around the corner, through September 4th. About our program, the 7 weeks Getting to the Roots course is designed to teach the students the difference between positive law and negative law, and how constructive language is used to reshape jurisdiction to deprive the people of their inherent rights. Moreover, students will learn the methods of how words are reconstructed from one language to another, thereby gaining insight into the morphological connection among the variant forms of a word in the different languages. Enroll now. Go to UnitedRespublicaMorocco.com and click on Academy of Providence. Once again, enroll now. Go to UnitedRespublicaMorocco.com and click on Academy of Providence. I thank you again. All right. The House of Reawakening Mind. I am Shem. He is Shem Malachi Bey. I am Abdullah Mosi Bey of the Moorish and Pure Restoration Caucus. All right. I am also co-founder of the Academy of Providence. My co-founder, Tamara Ill.
Yes.
All right. So we bring to you, all right, Academy of Providence, this upcoming course and other courses that you can go to the UnitedRespublicaMorocco.com, Academy of Providence, and look at our past classes. All our classes are recorded. So let me bring that point. All our classes are recorded. They are broadcast live via Zoom. We have the in-house presence as well as a large Zoom presence. So if you can't make it on Saturdays, because the classes are recorded, you can still enroll in the class and take it and watch it the next day or during the course of the week. All right. I just wanted to make that point. The classes are recorded. All right. Thank you again. So we will see you next time on the House of Reawakening Mind, second Friday. Every second Friday of the month, Shem Malachi Bey and I are on the House of Reawakening Mind platform. Thank you again. Assalamu alaikum. Veda Makum.
Shalom.
Peace.
Shalom. Shalom.